topic originally was protection of human rights in general. So I, in the chapter planned for the book, I addressed the issue of different levels of human rights protection and relation and possible conflicts among them. Then also I addressed, because of the countries taking part in the project, the problem of transitional justice was a peculiarity of our countries after 1890 to go through a period joining the international human rights protection by a special burden from the past. And then I tried to show the protection of human rights on the specific topics. First of all, the right to education in the European Convention on Human Rights, also in the context of the identity, not of constitutional identity, but the identity of groups from minorities to nations, in the case of the court, and also this included the minority problem, which probably overlapping with other chapters, but I strictly limited myself to the case of the European Court of Human Rights. And then I addressed the recent challenge before the court, the problems with digitalization. I saw that this is a very good field to show that a convention, a human rights convention, traditional classic human rights, how can answer to challenges which, of course, in the 50s or in the late 40s, when the convention, the European Council and the convention was formulated, didn't exist at all. So, as regards the protection of human rights, I addressed the national levels in constitution, legislations, and international levels in treaties, convention, covenants, from the Human Rights, the Universal Declaration of Human Rights, to the Charter of Fundamental Rights of the EU. Of course, this interaction of national, domestic courts, constitutional courts, regional, international courts, etc. It has also a positive side, of course, because it suggests that there is a multi-level and multiplied protection of human rights, but on the other hand also creates problems among these different levels of protection, of course. And it's not necessary to introduce the European Convention of Human Rights here. Just let me say the sad actuality that the 47 member states on the 16th of September will change to 46, as Russia, who otherwise ceased to be part of the Council of, member of the Council of Europe, with the exception of the Convention and the Court, from how to say, questionable interpretation by the Council of Europe and its organs, they remain for 6 months in the Convention and in the Court as well. The European Court of Human Rights is also challenging to show how faces new problems, because this court was planned to have a function completely different what that has today, and this inner contradiction gives a special tension for our everyday work as well, because this was a very court with a few cases, limited number of states, with a huge, how to say, respect for the member states, and then after the enlarging of the Council of Europe, basically a new court was created in '98 with an incredible caseload and with the possibility of individuals to challenge their states, and also you can see that while in the first 40 years, slightly more than 800 judgments were delivered by the court. Now, yearly 2,000-3,000 judgments, and of course there is a huge number of applications pending. So I now just limit myself to the digitalization problem, and also from that only two concrete problems. Firstly, let me mention the advantages and the disadvantages this cyberspace age. Of course, it facilitates transparency, opens up new perspectives for freedom of speech, addresses a wider audience, extends the possibility of political participation, and access to knowledge in education. On the other hand, without mentioning all possible problems, the filtering of the content of communications, the blocking access to internet and other ways of communication, censorship, surveillance of communication, creates a human rights problem, and also it, creates new inequalities like the digital divide, the gap between people with effective access and those without minimum knowledge, and also might lead to extreme concentrations of power. From the case law of the Strasbourg court, I just picked the internet and the freedom of expression problem that relates to the classical Article 10 and the data protection and the internet through some cases. As for the internet and freedom of expression, you know the Article 10 of the Convention that, in other words, says that you have the right to responsibly say and write what you think and to give and receive information from others. This includes the freedom of the press, according to the case law of the court. The famous Delphi versus Estonia judgment, the Grand Chamber judgment from 2015, is pronounced that Article 10 of the Convention applies to the internet as a means of communications as well, not only to the classical forms of expression and speech. As you know, generally all rights protected by the articles of the Convention, there is a three-part test applied that whether the limitation on the freedom of speech, also in context with the internet, is prescribed by law, pursue a legitimate aim, and is necessary in a democratic society. In other words, that there is a pressing social need for the limitation, and it is proportionate with the limitation is proportionate with the aim of the limitation. I mention a case against Ukraine, Paczolay versus Ukraine, that here the court at first pronounced that it is a positive obligation for the state to create an appropriate regulatory framework to ensure effective protection of journalists' freedom of expression on the internet. So while traditionally the court protected in a negative way the freedom of speech against intrusion by the state, as also in the case of other articles, other classical freedoms and rights, it pronounced that there's a positive obligation on the state to create an appropriate framework to protect journalists, even on the internet. In another case, Stoll versus Pitzer is not so important, but here is the very well summed up the concept of the responsible journalism. Responsible journalism that might justify certain limitations on free speech. In the court's case law, they said that the journalist should act in good faith, provide reliable and precise information in accordance with responsible journalism. And coming back to Delphi versus Estonia, here is that the internet news portal may be held accountable for offensive comments posted on the portal by users. So he tried to first face the problem of not only just expand to the internet, the classical protection of free speech, but also to set up the responsibility, how responsibly they have to act, and set up 4 criteria for liability. The history nature of the comments, the fact that the comments were posted in reaction to an article, the insufficiency of the measures taken by the applicant company to remove the comments, and finally that there was a rather light sanction imposed on this company. The court found no violation of the limitation and the sanctions on the company and on the portal, news portal. But here, this 4 criteria liability test was set up that is used by the court even later on. We have a case in the grand chamber in the future. Since the first case since Delphi addressing the same issue, I wonder what will be any changes on it. And then stated in one judgment that the publication of false information on the internet is not protected by the convention and by the court. So just the 200 case, what is the Magyar Tartalomszolgáltatók Egyesületben leader is a special pleasure at the court when colleagues try to pronounce Hungarian cases. And so this case, was my predecessor, Professor Shadow, was at that time the court, although so it was before my term. This is an interesting case that reassured that internet news portals had to assume duties and responsibilities, but set up the standards to decide on how the domestic courts balance the different rights and duties. So here the court, the Strasbourg court, concluded that the Hungarian courts and the domestic courts had not carried out a proper balancing exercise between the freedom of expression and the real estate website's right to respect for its commercial reputation. And this is of course part of this what is politely called the dialogue of the courts, I mean the international and domestic courts, which is not always the most friendly dialogue, of course. And then a case, the Magyar Yeti ZRT versus Hungary, a case that, honestly speaking, I like very much. Here the applicant company was liable for posting a hyperlink. The hyperlink that was had a defamatory content, but they just posted it without any comment or any evaluation of the hyperlink, and they were fined for that, etc. But then the Strasbourg court decided that we have to decide whether the posting of a hyperlink without any evaluation and comment could lead to a liability of the company that posted it, or the portal that posted it, and the court concluded unanimously that such a kind of objective liability for using a hyperlink could undermine the freedom of information and have a chilling effect on freedom of expression on the internet. Go to the other topic, that is data protection and the internet. Here we have Article 8, the right to respect for private and family life. This is the Jolly Joker of the convention, where really the court uses this article for all possible reasonings protecting rights that are not pronounced in the convention. However, I think that in the context of the data protection, the court's case law is interesting. While personally I think that sometimes we, to a certain extent, abuse this Article 8 for different reasons. So the basic principle set by the court for personal data protection is that it's fundamentally important in the context of the right to respect for private and family life, that private life includes the privacy of communications, that internet although goes under the umbrella of privacy of communication, is a different information source, different from the printed press, and finally coming into the possibility of positive obligations put on the state to protect private and family life effectively. Among others, cases that came to the court, a great variety of cases regarding genetics and information technology, retention of data, national and European databases, interception of external communications, surveillance of the internet and other kind of communications, then monitoring of the employees' telephone, email, internet usage, and personal information on the internet which was not meant to be posted online. Here, maybe just a comment on the national European databases, which arguably will arise more frequently, I think, in the near future before the Strasbourg court. Given the proliferation of such databases on the European level, one could cite the Schengen information system, customs information system, the visa information system, European fingerprint database. So these systems are coupled with an increasing desire to share information, to cooperate, but together with the increased concerns over the security, danger of terrorist attacks, immigration problems, etc. But also it's clear that all these databases interfere with the protection of private life clearly, and the court has been particularly vigilant as regards the duration of retention of these data and the existence of a real possibility of requesting their deletion after a certain time or certain period of actions. I will finish with two examples, with two cases. One is the monitoring of the employees' internet use. It was a Grand Chamber judgment 2017, Barculescu versus Romania. The company that employed the applicant monitored his electric communications and this fired him from the company. Then the Grand Chamber found a violation of Article 8, saying that failed to strike a fair balance between the interest at stake, namely the monitoring his electronic communications, controlling the content of these communications, and the domestic courts didn't balance in an appropriate measure the right to respect for private life. And finally, the recent case that attracted quite wide interest is the Big Brother Watch and other versus United Kingdom, a case related to the Snowden scandal. The applications by certain companies were launched after revelations that the Snowden scandal programs of surveillance, intelligence sharing between the United Kingdom and the United States. The case concerns three different regimes: the bulk interception of communications, the intelligence sharing with foreign governments, and the obtaining of communications data from communication service providers. The court, both at the chamber level and at the Grand Chamber level in May of 2021, found the violation both of Article 8 and 10 because of the bulk mass interception of communications and the obtaining of communications data for the service providers themselves, but find no violation of the intelligence sharing between the two governments, generally with foreign governments. So the reasoning said that there was insufficient oversight, most of the selection of internet bearers or interception, the safeguards were inadequate, were not really effective safeguards, but the intelligence sharing didn't violate either of these articles, and although the regime for obtaining communications for the communication service providers was not in accordance with the law, the safeguards were not sufficient in respect of confidential journalistic material. So, quoting this sentence from a Human Rights Council, the same rights that people have offline must also be protected online, I can conclude that the European Convention that adopted in 1950 formulates in Article 8 and 10 traditional human rights. However, the court, by evolutive interpretation, how we like to call it, extended the interpretation and application of the respective traditional texts, adjusting them to the new challenges of the digital era. Article 10 applies to the internet as a means of communication. Although internet plays a much more decisive role in everyday life than traditional forms of free speech nowadays, it's based on interactive two-way communication, it's extraterritorial, addresses indefinitely large community. As regards the protection of personal data, is not identified as an autonomous right in the Convention. However, the Strasbourg Court approaches the violation of this right under the umbrella of Article 8, the protection of private and family life. Internet, as other forms of communication, raise controversial issues that need the balancing exercise of judges, balancing between unlimited free use of new technologies and regulatory limitations on state and international level, as well as protecting at the same time individual freedom and public interest, and certainly, of course, to respect the subsidiarity principle and the margin of appreciation of the member state vis-à-vis the case or the concept of the Strasbourg Court. So thank you very much.